Good evening to all our attendees. Thank you for joining us today for this webinar, which is a part of our debrief webinar series. As we all know, our speaker today is Ms. Rajani Iyer, who is a well-known and well-renowned senior advocate in Bombay. She's very kindly agreed to address us all on the topic of ADR, the way forward in post-lockdown era. Now, this post-lockdown era is a time which may be filled with a lot of suspense and doubt for many of us, more so for the potential litigant and her lawyer. But conflict resolution within the judicial system as entirely depends upon courts functioning and perhaps courts functioning normally. Uh, it's unlikely that courts may go back to normal functioning in the near future. Even if they do, the manner in which this pandemic has affected and disturbed the judicial system may perhaps have shaken the confidence that the litigants have had in it in the past. So there are some options that, as lawyers, we may have to look at. But before we invite Ms. Iyer to deliver her lecture, ma'am, how have you been coping with this pandemic and the lockdown that has followed?
Very well. I have been observing the Lakshman Rekha perforce, except on 3 occasions when I've had to go out for essentials in the last 45 days, because I've got a more senior member in the family than me.
I
So
see.
I'm the younger one, and therefore I have to do outside errands. Otherwise, it's been good. I've been catching up on sleep, and I've been catching up with friends.
That's wonderful. Thank you so much, ma'am, for agreeing to deliver this lecture. And with this, now I invite you to make your address.
Thank you, Abhay. Hello, friends. At the outset, congratulations to the organizers for the several lectures on diverse subjects, both to inform us on a variety of these subjects and inform us about their relevance in today's India. My personal thank you to Debrief Conversations for inviting me to participate in this series once again. The subject which I will be speaking on is ADR, but it is not limited to the conventional ADR that we have been introduced to over the last couple of years. Because there's also another definition of ADR with a slight twist, which I would like to introduce to all of us. The reasons for me to choose this subject are the several incidents and cases of very many members of our fraternity facing harsh times financially. Some amongst us have modest years of practice but large responsibilities. Others have large establishments and even larger financial responsibilities, but both with perhaps no current income as enjoyed in the past. The extent to which a number of us are dependent upon work done or new works or accounts garnered on a daily or weekly basis to earn our professional income has been highlighted by this COVID virus. Much has been said and discussed in India about the breakdown of the legal and justice delivery systems through the court-centric institutions and about their functioning or non-functioning. But all this has been from the standpoint of the consumer of legal services, that is the litigant. Today, in this COVID-19 era and in post-lockdown or lock-in era, we have to discuss this issue also from the standpoint of another equally important participant in the current delivery mechanism at the taluka level and the district level and upwards. And whether it is across the rural, semi-urban or urban zones or across the village, the small, medium, or large industries zone. And that is you and me as advocates, professionally trained advocates who will have to reboot in more ways than one. Under the Advocates Act, once qualified and enrolled, it is we who are the interface between the presiding officers and the litigant client in courts. A majority of us earn our professional sense of satisfaction, our sense of peer acknowledgement, and our professional income from being such interfaces. Some of us also have professional income from what we call a table work practice, such as drafting, conveyancing, wills, estates, probates, and what have you. However, all of us as lawyers will not be able to go back to and to work and to the ways and manner of functioning of pre-March 2020 days, namely crowded courtrooms and case cause lists, a crawling list of disposal of old cases, disappointed clients living on hope and a prayer, and hence relying upon us, their interfaces, as saviors. It is possible that such reliance on us as the mandatory interface in the court centered system may, and most likely may not, return as known in the pre March 2020 days. The return, if at all, will only be with changes necessarily, i.e., changes in our mindset, changes in the client's expectations, changes in the manner of an audience before any presiding officer in a court, changes in procedures of the courts, changes in the collective thinking of potential litigants, a hesitancy perhaps in approaching the existing judicial and justice delivery systems, which they find are not functioning as they have known it to function. Such hesitancy would be on account of various factors, which is what we have to start thinking about. Perhaps the absence of the wherewithal in the clients, on account of legal limitations of mobility of both the clients, their advocates, and the machinery required for litigation, on account of their past experience in courts, which is what Abhay referred to in his opening submissions, and on account of the absence of any known mechanism which they have come face to face with in the past or seen in movies. So, apart from the changes that will be introduced in the manner in which courts as we know it will be conducted, there will be required perforce a change in the manner in which we, as practicing lawyers, will have to think. Think tanks of lawyers have gotten together and submitted suggestions to the Chief Justice and others. But to do what? To prevent overcrowding in courts, regulate the number of litigants and personnel in courts, staggering of court sittings, fixed time slots for court cause lists, managing of the court's judicial time. The Supreme Court, too, has for some time now, and with more urgency since March 2020, advocated the use of technology in the functioning of courts. The immediate feasibility, however, of such distance resolution, hearing via video conferencing of all cases filed till date in non digitalized form in all courts is going to be an exercise of climbing the learning curve with no one having any clue about when this curve, this learning curve, will get flattened across the board for all courts, whether in rural, semi urban, urban, or metropolitan India. Apart from the state administration, not even a large number of us, lawyers, ranging from those who have just entered the profession to those with years at the bar, have the prerequisites for distance resolution in courts, such as physical hardware or the requisite environment vis-a-vis continuous electric supply, continuous broadband or Wi-Fi connectivity, soundproof working space, technical know-how to conduct cases other than courtrooms, and what have you. Will lawyers be required to conduct cases from predetermined cabins or rooms with all facilities provided by the administration? Or will the lawyers be permitted to use their private equipment at their homes and offices? How will privacy, confidentiality, non recording of proceedings, etc., be ensured if it is from the private homes or offices? What if lawyers are not permitted to commute to the secured cabins and rooms set up by the administration, especially those aged 65 or living at a distance from these precincts which house either the courtrooms or these sanitized cabins? What if lawyers do not have offices but are functioning from the bar rooms and the court premises, such as the bar libraries? These are questions which I state only to bring the magnitude of the change that we as lawyers will have to get used to live with, and also find answers to accommodate. My brief today is not to deal with or list out the possible situations that we as a fraternity may be faced with in a couple of weeks or months, but which reality may continue for a couple of years or more. It is that, given these various realities thrown up by COVID 19, we as advocates are faced with. There is another unique ADR which has emerged, one with a twist as far as the words are concerned, and which I have, for the purposes of this session, called Advocates' Distress Resolution. The distress faced by advocates requires resolution. This too is an ADR. How do we do that? Perhaps the traditional alternative dispute or difference resolution being resorted to is the answer. According to me, this will have to be resorted to by us as a fraternity in a big way. Of course, innovations to meet with local or immediate exigencies as to procedure in pending matters, as to suggestions for pre litigation cases, conduct of such alternatives will have to be thought of. The various options, paths, or solutions which we as lawyers must explore in order to overcome the present uncertainty, and which I commend for us to consider very earnestly, is adoption of ADR, but more particularly mediation and or arbitration. These options have to be explored for assuring our current clients and post-COVID-19 lockdown period clients quick and effective resolution of their travails, even when the support of the court-centric system of justice delivery is not feasible or available. This option will have to be seriously considered, even if the court-centric systems do start to function in the green and orange zones, given the appeal of appellate courts being available but being in the red zone. Let me here share with you an anecdote which a senior member of the bar when I was a junior shared with us, the legendary Mr. M.A. Rane. He said it was either his own case or a case of one of his colleagues. When after having succeeded in a first appeal, a telegram was sent off to the client who was in Mofassal areas saying truth prevails. Back came a telegram from the client asking the lawyer file appeal immediately. This lure of an appellate court, therefore, will ensure that litigation continues if there is no resolution. And that is why I'm saying that we have to explore alternatives for quick solutions. We as lawyers must stop looking at mediation only as a means of avoiding a hearing, avoiding a judge, or buying time. As lawyers, when any client comes to us, they know the real facts. Based on the information given to us, we as lawyers know the potential legal limitations, whether of our client's case or of the potential opponent. As lawyers working as a fraternity, we have to also realize that most clients henceforth may not have the capacity to finance long drawn out confrontations. Several among us, too, with no foreseeable opening up of the court centric work at pre March or at February 2020 levels, will not be able to manage our lives without some regular professional income. A way out of this conundrum is for us as lawyers to gauge the mood of the clients and the parties and suggest to them various options which does not involve the courts. And we must recommend this strongly to them. One is talking about the problems with each other, with or without the assistance of lawyers and or third parties. Negotiating a solution, conciliating of the differences through a conciliator, trained conciliator, mediator, mediating of the differences with the assistance of a trained mediator, a restructuring of the contract which has led to the problems, a novatio of the contract, given the force majeure situation brought up by the COVID virus, and consensus building for purposes of formulating solutions. What a new creature this is. Is this some other COVID-19 sort of virus? I'll come to that in a minute. If these not be available as potential solutions for the problem at hand, the option of arbitration, despite there being no existing arbitration agreement, should also be explored. Why do I commend these alternatives? I do so as these are options available now, immediately, without any court centric support. It is feasible inter se amongst lawyers and the fraternity of lawyers. Lawyers have mediation training, they have specialized domain knowledge. Use this for resolving the disputes. It is also another reason which I will state without any hesitation. It is for generating work for and amongst lawyers whilst finding solutions for clients. It is for lessening the social disquiet and anxiety and tension amongst potential litigants and for contributing our little bit as lawyers in these socially challenging times. Apart from all this, aggressively exploring these options will enable each of us to contribute in a very small manner, perhaps, towards lessening of arrears, helping our clients in these challenging times of facing an absence of remedy or thinking that they are remediless, ensuring at a personal level professional integrity and the maintenance of professional integrity even whilst earning a professional income. Such resort to ADR will also result in the advocate's distress being redressed. Did I say that correctly? The advocate's distress being redressed. Sincerely, this is no laughing matter. Some of us may not have had court presence, but we may have, and we ought to develop the art of negotiating or of generating a climate conducive to settlement or being able to work on the psychology of potential litigants and steering them in a path to avoid litigation. All this will ultimately help the resort to ADR. Many of us as lawyers may lack court craft and strategizing ability, but may have an abundance of empathy and capacity to listen. And we must develop these talents with training and to take up mediation work as negotiators and even mediators or arbitrators over time. I do believe the way forward in the post lockdown or lock in era is for young lawyers practicing in whatever specialized field they are wanting to, either in the criminal or non criminal segment of law, be it labor, rent, fiscal, commercial, all, to look at being self sufficient as a fraternity and look to other members within the fraternity for resolving their clients' problems. The moment we accept ADR also as a means for or of self-help amongst and for lawyers. ADR will acquire an added edge and become an effective alternative being advocated by us lawyers, as we have a vested interest in being self-reliant and being a lawyer-centric system of dispensation of justice. And a lawyer-centric system capable of having solutions for clients which is non-court centric. The acquisition over time of a reputation that you are a lawyer, not only straining to ensure speedy resolution of problems without resort to the dowpage of court proceedings and procedures, but having the training and the experience in the field which itself attract other clients. Even better than arbitration would be mediation, in my view. Why would be the natural question. It is for these reasons. Mediation is where the clients can participate in resolving their differences. It is a tremendous key for releasing the pent up emotions, which itself is a healing process and which helps in reducing the aggressiveness with which they want to go at their opponent, and will help in softening of their expectations, which is what we must encourage as a fraternity. And apart from the participation by the clients and the litigants, into inverted commas litigants, because we don't want them to go to the stage of litigation, we as lawyers can also participate in this process. As what? And doing what? As a mediator, if we are trained to be one. As a negotiator, appearing before the opposite party or even before meetings held by a mediator. As a lawyer, if required by the client, to make a decision or choose an option of the very many options thrown up by a mediator as to which would be proper or correct for his interest or her interest. As a draftsperson of necessary documentation to reflect or effectuate such mediated resolutions. Mediation is where the participating parties would not be limited or hindered either by the COVID-19 virus or the trappings of a systemized court or arbitration. Why would they not be hampered? Because mediation can take place even if parties are not face to face physically, which may be required in the more formal option of arbitration, especially if there be some form of cross examination of witnesses involved. Mediations can be conducted with the parties being in two or three or more locations by resorting to technological innovations, be it video or audio conferencing via WhatsApp, Zoom, Google Chat, etc., etc. But to get to this, you and I, as lawyers, must accept that it is up to us to convince our clients that the possibility of the sound and tinkle of money, if not possible immediately, then at least in a structured manner in the coming future, rather than years down the road, is preferable to the sound and fury of one's emotional and mental traumas and tensions. To suggest such exploration by our clients, even in pending matters, and also in, as of now, unresolved differences between friends, friendly loans, for example, or relatives, be it in the case of wills, family arrangements, family relations of husband and wife, child custody, or between parties to transactions, commercial transactions, housing, be it society, redevelopment, employers and trade unions, creditors and debtors, unless there is a legal bar. For example, company matters, oppression, mismanagement, not possible. Rent Act, separate forum by law. But if it can be at the pre litigation stage that a compromise can be brought about, we must explore that. And lastly, to convince ourselves that we must ensure that our inventory list of pending matters must have the shortest possible shelf life and not fall into the category of either file an appeal instruction from our client or the other classic anecdote that was told to me when a young solicitor went back to his father's office and said, Dad, you gave me this matter, and in the first attempt, I have settled it. And the father turned around and said, What? Who do you think helped me to get to this knowledge? You have cut off your own feet by settling this matter. These must remain to be anecdotes. The new future will not tolerate such reality. Given our individual levels of practice, expertise, or comfort, we can opt for one of several variations and levels of non litigated resolution of disputes and differences in courts as an arbitrator or mediator, as a neutral evaluator of a dispute, as an expert advisor on any point of outstanding dispute between parties in arbitration or mediation, based on which advice that problem can be mediated or resolved or arbitrated upon without going to court of law. As a draftsperson of negotiated settlement in mediations, as an advisor to maintaining and presentation of records, especially in arbitrations, as a person who maintains and presents pleadings and documentation in digital form for and in arbitrations, because the traditional method of having large arbitration rooms where 10 or 15 of us are present together, given the requirements of physical distancing and social distancing as it is otherwise referred to, the absence of rooms without ACs, but with adequate circulation of air to house such large number of people. The commuting to these arbitration centers, all this would become a challenge, and therefore it may have to be online arbitrations that we may have to go towards. This last, that is digitalized presentation of pleadings, documents, and what have you, will require preciseness and conciseness in whatever be the language of the proceedings, because it need not necessarily be in English. At the taluka and at the district levels, the parties and the stakeholders may conduct the entire proceeding of negotiation, talking, mediation, arbitration, whatever it may be, in the language of the soil and not English. And it is in that you have to maintain your records. Consequently, digitalization of records from the inception is also going to be important, especially if it be arbitration. To rule out all this, I therefore prefer mediation, because mediation is where the parties have their records and the mediator does not maintain any records. The proceedings before a mediator can never be used as a record. And yet, because of the participation of the parties themselves, there is no need for records and records to be maintained, filed, or otherwise processed. Given today's day and age, I, who am not at all tech savvy, have been able to set up my phone for the purposes of this Zoom conference. But as I tell my friends, I have to go back to nursery school. I will have to learn how to operate a laptop, how to operate a desktop, how to live without or with a tab, how to interface between all these and the large screen, which is my TV screen. I do not have Netflix because I don't like to strain my eyes, but strain it I will. So, do I have to go in for laser treatment and 20/20 eyesight? But will anybody be willing to do a laser treatment on my eyes? Therefore, I better get down, knuckle down, and learn the tech savvy requirements of today's day and age. I will do so. I can't do it during the lock in or the lockdown period because I can't have teachers coming across and teaching me. Or nor can I go out and buy all this physical hardware. But this is the new reality. Given this new reality, there is another reality out there in the market: online dispute resolution. Online dispute resolution is a platform which is being offered by various tech savvy persons for conducting online mediations and online arbitrations. If and when a matter is referred to them for mediation, they have a panel of mediators, one of whom they will appoint for a predetermined fixed fee. This is a very important and relevant issue which we as lawyers can offer our clients in the post lockdown lock in period. Money is hard to come by even for our clients. They cannot face escalating costs. Such online resolution of disputes, ODR, online dispute resolution, at a lump sum amount, which is of being offered by these platforms, has to be explored. has to be inquired into. We have to get to know this. We have to get to know about the facility. We have to get to know how they operate. And we have to know how we can recommend that to our clients and be part of the entire process as well, as I have outlined above. These are new and interesting developments, but it is not unknown the world over. There are various forms of arbitrations and mediations which are available. The mediator can be a trained advocate. The mediator can be a trained specialist. The mediator can be a person learned in law, so long as there is mutual trust of both parties in the mediator. If the dispute is relating to purchase and sale of cotton, I would not like to have as a mediator a person who deals in steel. Likewise, if it is a dispute which relates to well water being used by neighboring farms, I do not want to have a person who manufactures spectacles being associated with that industry being the mediator. This is what we mean by domain expertise. That is very important. And it is a skill which we as lawyers acquire because that is the lifestyle we've grown up with, that is the environment in which we have grown up or we are familiar with, because that is what the people in our family are associated with. We have to learn to channelize all these hitherto unknown areas of expertise, I would say, and make it work for us in our profession as well as for the benefit of our clients. This is a challenge, and this is the reality of post lockdown. I may or may not be able to make the most of it in a court centric system, but I can definitely make the most of it in a fraternity centric, lawyer based approach to resolve the problems faced by my existing clients or my potential clients via mediation, via arbitration, and a consensus approach to ensuring there is no litigation. I would like to end by saying that the challenge, therefore, before us is to get from a position where people, including ourselves and our clients, are convinced that there is a strange new system where courts are not involved for sorting out their problems, to a position where they learn that such a system exists and can be resorted to by them, to a third position where they hope that it will work for them, having participated in it and seen how it works. And having participated in it, they strive to make it work for them. To finally, the fourth stage, where they start wondering why it was not thought of by them as a norm when they came to the advocate and asked for a case to be filed, and not ask for a case to be filed, but ask for their problem to be resolved. when this final stage is reached, and I will do not say if this final stage is reached because it's in our hands to ensure that it is. That will be when we as lawyers, as a fraternity of lawyers, can congratulate ourselves for thinking differently in the post-COVID-19 era. Such thinking differently or out of the virus box is also helpful for our fraternity. Thank you very much. I think I have taken the mandated 40 minutes. I end here now. Thank you for a patient hearing.
Thank you, ma'am. We have some questions for you if you don't mind.
Yes, of course, certainly. But if
Uh,
I have a suggestion.
yes, ma'am.
Can I also suggest that if we have other mediators or arbitrators apart from students who are in this talk, open it up for them as well, because we all have so many ideas having practiced this branch of law that it's always going to be welcome for our young colleagues, if that is possible. It's for you to
Unfortunately,
decide. You're in the driver's seat.
yes, unfortunately, that's a wonderful suggestion, but unfortunately, in the on the platform that we're using, which is the webinar platform,
Right.
the access that attendees have to the facilities is
Switch off.
limited, unlike the meetings platform.
See, this is where it goes to show I'm not tech savvy.
But
All
there
right.
have been a few questions which have been coming in.
Yes,
And
of course.
those
Tell
to you.
me.
One of our attendee asks that instead of ADR, can't we look forward towards e-courts as a sort of um, manner in which to ensure that the professional practice keeps going? And I have something to add to this question. Um, One often sees that litigants are a little apprehensive towards going to alternate dispute resolutions and have more faith in the traditional system of dispute resolution, which is courts. So, how do we overcome that challenge?
May I know the name of the attendee who's asking this?
The gentleman or the lady has sent it in an anonymous manner.
All right, fine. Uh, the reason why e-courts may not be the answer is because the hardware required for e-courts in our taluka courts, in our district courts, in our high courts, in our supreme courts, in our range courts, in our cooperative courts, in our tax tribunals, in our estate and, what are the tax tribunals, labor courts, um, uh, you know, uh, the alternatives to the writ court with the Maharashtra state and the central government employees tribunals. How and when is the hardware going to be installed for such e-court functioning? The next 5 years, the next 10 years? Again, from where are these e-courts to be addressed by the lawyer? That is what I said, from the privacy of our advocates' homes and offices, or from a secured cabin or room made available by the administration. If it is from the latter, how do I get there? How do I commute there? Today's situation is that there has been a recurrence of 5 instances in Wuhan. This virus may just reappear in various forms. How long is this uncertainty going to continue? In and during this uncertain times, how is the hardware going to be set up? E-courts themselves are a challenge for the quantity of work involved in setting them up. For e-courts across the board, what is the assurance of continuous electric supply, of continuous broadband or Wi-Fi supply, connectivity supply? If I'm doing it from home, Do I have two broadbands, one which the family will use because it's locked in with me, and one which I will use for my professional requirements? These are the issues which are potential roadblocks in the immediate future. Till then, what do we do? Till then, do we fold our hands and stop practicing and having an income? A large number of us may have other sources of income, but a large number of us do not. Then what happens? The second issue that you raised, can you just tell me what you added to that, Abhay? You had an
Yes,
you added to the question. What
yes.
was that
I
about?
said that there is often
Yes,
uh,
the reluctance.
reluctance on the part
The
of the
re-
litigant.
Now the reluctance to go to ADR is because till now you and I as advocates didn't have a vested interest in ADR. And that is what I'm asking and seeking we as lawyers do get a vested interest in ADR as being our main source of bread and butter. We will then tend to sell that to our clients and not only sell it, but put in our best to make it effective. For example, I was told of a wonderful situation where Lever Brothers, because they mediated the settlement with their workers, found that their price of shares in the London stock market increased by a couple of pennies. Now, that is the height to which you can promote ADR. But it is in my hand as an advocate, to tell my client it is feasible, it is possible, it is good, not only for him, but side by side also for me.
I see
It's
that
a
there is
mindset change. It's a mindset change. It'll take a long time, but it has to come
on picking
for
up
us
on
to survive.
one of your comments. We have another. I don't know why everybody is sending anonymous questions. We have another anonymous attendee who asks that ultimately orders passed by ADR forums end up in courts.
Yeah.
So how
Mm.
does one persuade the client to go to ADR? And what is the carrot that one holds in front of the client?
The carrot in today's time is that you don't have staying capacity, my dear. You want a resolution of your difference and to get on with business whenever and as and when it is possible. Get on with your business and not worry about pending matters. That is the carrot. One. Two, if it is mediation, it is not a order which lands up in court because there is a mediated resolution through consensus. Therefore, what do you appeal against? You can't appeal against anything because you're resolving the issue. That is why I prefer mediation, because it's a resolution with participation of the issues concerned. It's not something which has been handed down. As far as arbitration awards are concerned, yes, it is for us to ensure that for the mental well being of our clients, we try and ensure that we make them see the reality of the bad points and good points of their case. Unless it be something which is really out and out contrary to the laws of the land, public policy of the land, and the limitations which are there in the act itself, you may want to go to a court of law. But the court of law today is not going to entertain you. And therefore, that reality of ADR landing up in courts itself is today limited. But at least, there is a end to the issue. There is a finality to the issue. The need for finality is something that we have to emphasize to and for our clients.
I want to ask you a question about mediation, which has come from Advocate Nirja Joshi.
Yes,
He says that you suggest that mediation is the way forward, but very often parties come to a lawyer only when they have failed to reach some sort of a settlement, and then they resort to either court proceedings or arbitrations. So, in such a circumstance, what one assumes may be a hostile client, how does one persuade such a client to go back to the negotiating table?
Nirja, thank you for this question because it is a situation which will face us and has faced us. Even though they come to us after talks have failed, what you must try and find out is whether the talks were amongst the parties without the handholding by a lawyer or with the handholding of a lawyer. Were the talks with or without the assistance of a trained negotiator or a trained mediator? Because if it is something where two hostile persons try and say we will talk things over, and otherwise I'll see you in court without knowing the pitfalls in their respective cases, being pointed out because of the absence of a lawyer, a negotiator, or a person who holds their hand, it is the right time for you as a lawyer to point out the potential pitfalls and say, give it one more shot with trained assistance. Only then go in for a costly, a long drawn out proceeding in COVID times. Perhaps that is the answer, Nirija.
Thank you so much, ma'am. Um, Let me firstly compliment you for suggesting a topic which all of us have thought about in the back of our minds, but because it because we don't have enough answers, I think we were all scared to address it. Many of us don't know what the future or even perhaps what the present holds for us. But the pointers that you have given may help us identify how we can keep ourselves afloat professionally and consequently financially. So thank you very much. I really appreciate you coming on our platform, and we hope to see more of you in at one of our future events. It was a wonderful session, speaking for myself.
Thank you very much, Abhay. Inshallah, and all the very best to all of my young friends.
Thank you.
Bye bye.
For all our attendees, our next speaker is the Honorable Mr. Justice Sonak, who is a judge of the Bombay High Court. He will be speaking to us this Wednesday at 11:30 about writ jurisdiction and substantial justice. Do join us for that webinar. Please follow us on our YouTube and our Facebook pages. You can search for Debrief Conversations. And on Twitter and Instagram, we are Debrief Legal. So follow us there. With this, we declare this session to be over and wish all of you remain safe during these difficult times. Thank you very much.